Now we go to dispute settlement. Okay. So what do we mean when we talk about dispute settlement? We are talking about procedures for resolving disagreements between two or more parties to an agreement. So concretely, just to give you an example, in the Minamata Convention, this is one of the paragraphs in the article that talks about dispute settlement procedures. So the dispute has to be between parties, and it has to be with regard to the interpretation or the application of a particular agreement. So in this case, the Minamata Convention. That's what we mean by dispute settlement. And one of the big questions when it comes to MEAs is what is the exact relationship between an implementation and or compliance mechanism on the one hand and the dispute settlement mechanism. So in some cases, the enabling clause or the provision of the agreement that actually provides for the establishment of an implementation and or compliance mechanism actually makes express provision to say that the mechanism to be established or that is established under that provision operates without prejudice to the dispute settlement mechanism. That's why we had the case that Professor Fitzmaurice was talking about yesterday, where you could, in theory, be subject to a compliance mechanism and at the same time be brought then before the International Court of Justice because they operate separately. Although you could argue that if the issue relating to compliance is on the application of the convention, or in the case of a party that is allegedly non-compliance, the non-application of a provision, that it might constitute then double jeopardy to be brought before another venue. But the jury is out on the exact relationship, no? But this is what essentially a dispute settlement mechanism is. And there are several points to be made here. The first one is, maybe I start with the second point, that the dispute settlement mechanism is largely unused in the area of MEAs. I think one case was referred to yesterday, but it's one in a sea of compliance cases. And so the question has always been why. And then again, this explanation that I provide in the first bullet, it was actually given by Jutta Brunet, so it's not my explanation. One of the explanations she's given in a book on compliance is that the dispute settlement mechanism is not really compatible with the construct of MEAs because a dispute settlement mechanism is associated with this idea of state responsibility, whereby a state that has to show injury or interest is then bringing suit against another. And in the context of MEAs, what we're talking about, while one state could perhaps show direct damage, but what we're talking about usually is more a global threat. So it's not. Non-compliance with MEA obligations, they say, don't normally lend themselves to this kind of bilateral dispute, but are more appropriately addressed in a compliance mechanism, which in most cases is, as they say, facilitative, non-judicial, non-confrontational. So it's that setting that is more appropriate, they say, for non-compliance. And also, dispute settlement mechanisms are quite expensive and time-consuming. Not that compliance cases are not, but they are less so. And in some cases, non-compliance proceedings are probably take a shorter time than a dispute settlement proceeding. So those are some of the theories that have been offered as to why dispute settlement mechanisms are not so widely used in MEAs. Be that as it may, they do exist in most of the MEAs. So in theory, they could still be used, perhaps by a party, for example, who is not happy with the results of a non-compliance procedure. So that's one